All right. Welcome, everyone. I think we'll kick off in the interest of time. And as people are joining, we will just introduce ourselves. Welcome to our joint Young AFSA and BriefCo webinar series on costs in arbitration. So we all know that costs can either make or break a case or a person. So today's discussion is all about making sure costs work for you, not against you, as you build your careers. So to kick off, my name is Kirsten Volmerans, and I'm a committee member of Young AFSA. I'm also a partner in the commercial dispute resolution practice at Weber Wenzel. I specialize in corporate and commercial litigation and arbitration, having worked on a wide range of disputes across various legal forums. I've also had the privilege of representing clients from diverse sectors, including banks, auditing firms, construction companies, and energy sectors. So I've had a fair share of costs exposure. From Young AFSA, I'm also joined by Jonathan and Nelly. Nelly, would you like to just give everyone some background about yourself?
Thank you, Kirsten, and good afternoon, everybody. Thank you very much for your attendance this afternoon, and we do hope that this session will be of benefit to you, whether in your practice or otherwise. My name is Nelly Ndlovu, and I'm an advocate member of Group 1 Advocates, as well as the Johannesburg Society of Advocates. I'm also a committee member of Young AFSA. In my practice, both at the bar as well as at the sidebar, I've had the opportunity to advise and represent local and multinational clients in both private arbitrations as well as arbitrations which are facilitated through AFSA. In general, the arbitration space in South Africa is fast growing and being seen as a preferred option in respect of dispute resolution for a myriad of reasons, including the expediency of arbitrations and, of course, exactly what it is that we're here to speak about today, the associated costs with litigation. With AFSA playing a key role in managing and administrating dispute resolution processes in this regard. And it is critically important that when one considers dispute resolution and litigation in general, that the costs of this must also and always be borne in mind. Might I introduce Jonathan, who will also tell you a little bit about himself, and then we'll kick off with the substance of our discussion this afternoon.
Thank you very much, Nelly. Good afternoon, everybody. My name is Jonathan Barnes, and I'm a partner in the Dispute Resolution Department at Bowman's, specializing in international arbitration and class action litigation. In my practice, I've worked on a number of transactional disputes, contractual claims, mining-related disputes, urgent high court proceedings in various sectors, including mining, food and beverage, and the automotive industry. I've also worked on various cross-border disputes, including AFSA, ICC, and LCIA arbitrations from the inception of the matter through to the enforcement of the award. And this also includes the recovery of legal costs following the arbitral process. It's really nice to meet you all today and to spend some time with you this afternoon. And I hope that you'll find the session to be informative and practical. So to kick off, I think in general, we all know that any dispute resolution proceedings, whether through litigation or arbitration, can come at a significant cost. Very often, this cost will be quite high, having regard to the amount of work and time that goes into a matter. In particular, arbitrations can become fairly costly in instances where parties are required to pay for multiple aspects of the proceedings. For example, their attorney's fees, as well as any counsel they engage, advocates, the arbitral tribunal, which unlike in litigation with state judges, these people are remunerated directly by the parties who appoint them, the administration and initiation fees for institutional arbitrations, any fees incurred by experts who are led in the proceedings, the venue hire fees, and the transcription costs. So with all of this in mind, it's quite unsurprising that one of the most common questions that claimants have prior to commencing arbitration proceedings relates to what the costs of the arbitration will be, whether they can be estimated sufficiently in advance, and how these costs can be kept to a minimum or reduced where possible. So the costs of the arbitration, in addition to the arbitration's duration, are an important, if not determinative factor in a claimant's decision whether to start arbitration proceedings in the first place. This is especially true for cases with a low quantum in dispute, where claimants need to determine from the outset whether it's worthwhile commencing arbitration proceedings at all. So these costs should therefore always be considered by attorneys when advising their clients on an arbitration process, and they should certainly not be treated as an afterthought. Attorneys also have a duty to advise their clients on the cost implications of the various aspects of their proceedings and the possible outcomes on recovery or payment of the costs, and on what scale these costs will be recovered, at the end of any arbitration. Very often, the distinction between a happy client and an unhappy client at the end of an arbitration, whether or not the matter was won or lost, is the client's overall sense of satisfaction in the value for the money that they spent on the process and the manner in which the costs were managed by their legal team. So how attorneys assess and communicate the cost to benefit ratio of the arbitration proceedings to the client is extremely important. So while attorneys do not always get involved in the nitty-gritty aspects of exactly how the costs will be calculated at the end of an arbitration, they nevertheless have an idea as to what the likely costs outcomes will be, and they also know where to refer their clients for such cost calculations. In this regard, we know that specialized cost consultants are available to assist with this in the industry, and one prime example of that is BriefCo. As you may know, a legal cost consultant is a specialist in the field of legal costs who specializes in drawing, presenting, and opposing a bill of costs before the taxing master. Attorneys benefit by using a legal cost consultant as they have the added advantage of keeping abreast with the latest case law and developments in the highly specialized field of legal costs and taxation, and they are therefore able to present relevant arguments or counter-arguments during the taxation in an efficient manner. So when you engage a cost consultant, like someone like BriefCo, for example, they are very easily able to assist you with preparing bills of costs and oppositions to bills of costs applicable in all forums in South Africa, using technology and experienced cost consultants to guarantee a turnaround time of a maximum of 5 working days on preparing bills of costs, using experienced cost consultants with rights of appearance to attend taxations in all forums in South Africa, and mitigating the delays and costs occasioned by the court processes by assisting where appropriate to reach reasonable and accurate settlements of bills of costs. In this regard, cost consultants are therefore generally favored when it comes to the calculation and taxation of their costs, given their expertise in the specialized area, especially the experience with the taxing master. But this then links into the question as to how costs are dealt with in arbitration specifically. Kirsten will tell you more about the consideration as to the exact types of costs that can be included in arbitration agreements, but it's also noteworthy that parties will often seek to engage in alternative means of recovering costs post-arbitration proceedings, given that the traditional road to taxation by a taxing master has become a protracted one due to the long waiting times for dates on the taxing master's court roll. So in practice, what we've seen is parties are taking a more proactive approach in their arbitration agreements before their dispute is aired by arbitration, and they're agreeing that any taxation will be done by an independent third-party cost consultant, and that the ultimate allocateur provided by that cost consultant will be deemed final and binding on the parties as if it had been taxed by a taxing master. So in other words, they're circumventing the taxation process and the long wait times to get the matter heard by the taxing master by engaging the cost consultant services to help speed up the process. And this opens up a whole new side to the traditional taxation model, and it provides a new and updated role for cost consultants in assessing costs and determining them pursuant to arbitration proceedings. So with that, and having considered the role of attorneys and cost consultants in the cost process and arbitrations, I think it would also be helpful for us to understand the role and view of advocates in this process, where they were involved in these types of proceedings. And I'd therefore like to hand back to Nelly Ndlovu to hear her insights. Thanks, Nelly.
Thank you, Jonathan. That was very informative. What I will be discussing this afternoon, and I'll spend a little bit of time going through this, is the cost considerations in domestic arbitrations insofar as counsel is involved in this process once brought onto brief in any dispute, which viewpoints will include my personal experience in both advising and on strategically considering costs in arbitrations, specifically traversing the following topics. Firstly, counsel's role in assessing whether costs can or should be sought in arbitrations and how one can go about that exercise. Secondly, cost considerations in the high courts vis-a-vis those in arbitration proceedings, with specific reference to a recent and fairly instructive judgment by Wilson J. in the matter of Mashava versus NEXPTY Ltd and others, which is a 2024 judgment of the Gauteng Local Division of the High Court. Thirdly, and as part and parcel of this talk, I'll be dispensing some practical tips on how to best set up your case in order to avoid cost orders against your client, and particularly punitive cost orders. And lastly, how it is that arbitrators on the back of the aforementioned topics go about determining costs in arbitrations. Firstly, In determining whether costs can or should even be sought, that, as in most cases, is usually largely fact-dependent and would also be heavily influenced by a proper analysis of the prospects of success in your matter, viewed together with the conduct of the parties during the arbitration process, as well as the notion of reasonableness, all of this in which I will be unpacking. So when first assessing the facts of your matter, and by way of practical example, in which many of us have probably seen quite often these days, often where a claim is arbitrated and is, for example, based in contract, the contract itself may provide for the costs which can be claimed by a party in circumstances of a dispute. So it's always useful to properly scrutinize the factual and often contractual bounds of the dispute before pleading, which can be instructive of what may be claimed insofar as costs are concerned. Then, when looking at your prospects of success in a matter, which is a fairly important job, not only for counsel to interrogate, but also for attorneys, not every claim or defense warrants punitive costs or sometimes any costs at all. While it is important and very helpful to plead what costs are sought in circumstances where the claim or defense advanced is upheld by the arbitrator, this must also be pleaded and advanced in respect of what is reasonable against the facts and prospects of success in your case. I'll delve into this later with reference to the judgment I mentioned earlier. How one runs an arbitration is also heavily influencing where costs fall these days. Therefore, one must always be aware of advancing frivolous applications, poorly prepared pleadings, not adhering to terms and conditions and or the time periods which are set out in your arbitration agreement and the like. Your arbitrator is, in essence, and in that specific instance, basically the eyes of God, all-seeing and all-knowing. One's approach to a case will be remembered and could be factored in insofar as the issue of costs is reserved for the ultimate outcome and determination by the arbitrator. Cost considerations and determinations, as determined and treated in the high courts, are often relied upon and applied equally to costs in arbitration proceedings. So the general rule in this regard is that costs of the arbitration should ordinarily follow the result. This is the same principle that applies in the high courts. And now, given the recent amendments to Uniform Rule 69 in respect of counsel's costs on taxation, it is necessary for the costs order to identify the scale of counsel's fees, be it A, B, or C. Turning now to the instructive judgment of Wilson J. in this regard, in the matter of Mashaba versus NEX Africa and others. What happened in this matter is that the court ultimately dismissed an application, which it was of the view bore very little prospects of success, and reserved judgments in respect of the issue of costs. Upon delivery of the judgment, Wilson J. helpfully discussed Rule 67A of the Uniform Rules of Court, where the learned judge set out that cost orders in civil proceedings are made on one of two scales, that either being party-party scale or attorney and client scale. And in brief, just as a recap, a costs award on a party and party scale allows the person in favor of whom it was made to recover the cost that they had to incur in bringing or defending a civil suit, but only to the extent allowed by a set of tariffs, which are designed to keep recoverable costs within reasonable limits. This is where the notion of reasonability then comes in. Those tariffs rarely keep pace of the actual cost of legal services, meaning that a party and party cost order seldom permits for the recovery of legal costs that are rarely incurred by the party in favor of whom it is made. Whereas on the other hand, attorney and client cost orders allow the party to whom they were awarded to recover an amount much closer to the actual costs of the legal services that they purchased to participate in the suit itself. These orders are generally made against a party that has misconducted themselves in the course of litigation, against a party that has brought a suit or raised a defense which was so devoid of merit as to be a waste of the court's or the arbitrator's time, or against a party who has itself agreed that if they are successfully sued in a particular set of circumstances, they will pay costs on an attorney and client scale. And this brings us back to assessing the facts and looking at the documents in the matter which might provide for the issue of costs. These notions, as set out quite clearly by the High Court, also apply in arbitration proceedings, and how it is that arbitrators go about determining the issue of costs. The judgment by Wilson goes on to detail that Rule 67A addresses itself only to awards of costs as between party and party, and in that regard, its purpose is to permit a court to exercise control over the maximum rate at which counsel's fees can be recovered under such award. Interestingly enough, the court set a maximum recoverable rate for that work having regard to the importance of the work, the value and complexity of the matter, as well as a number of other aspects which are detailed under Rule 67A, sub 3, sub B. The court may also take into account, as I mentioned earlier, any failure to observe the provisions of the rules, particularly procedural provisions such as 30A, 37, 37A, as well as 41A, which we know is in relation to mediation, any overly long written arguments, any oral arguments, examination or cross-examination of witnesses which is problematic or overly long, or any other misconduct that might justify a personal cost order in the circumstances. Rule 67A3 provides that a court shall, when making a party and party cost order, indicate the scale in terms of Rule 69 under which costs have been granted. Now that's quite important because those scales have been inserted into Rule 69 sub 7 under the amendment, which is in the form of Rule 67A. And as mentioned earlier, those scales are scales of A, B, and C. C, of course, being the highest of the scales and would veer into the notion of punitive costs. They set the maximum rate at which counsel's fees may be recovered on a party and party bill. So this is fairly important and applies just as equally in arbitrations. So when you are preparing pleadings, either in the High Court or in arbitration proceedings, it's now best practice to expressly and from the very outset state what costs are sought and the scale thereof, if by way of example, your agreement is silent in that regard. Of course, as the matter proceeds, various considerations, as mentioned earlier, can change depending on the conduct of the matter and the like which counsel is permitted to advance and argue in closing. So by way of example, if there are a number of frivolous interlocutory applications that bear no merit, one may either request costs of those applications on a punitive scale and or reserve those for the determination of costs at the end of the arbitration proceedings. This then brings us to a summation of some practical tips and tricks on how to best set up your case in order to avoid an adverse cost order or costs altogether. And in this regard, I have 5 high-level bullet points. First, try to agree to costs where possible at the very outset in your arbitration agreement, particularly if you have reason to do so. You often see this in, for example, construction disputes, which can be fairly lengthy, involved, and expensive. This is a good reason to agree as to costs where it is possible. Often it's not possible, particularly in general civil disputes, but it is at least worth a shot, which Kirsten will further discuss in her section. Secondly, base your request for costs on the facts and the prospects of success of your case. This is tangible evidence which the arbitrator will ultimately take into consideration upon the determination of costs. Thirdly, plead what costs you see clearly with reference to the cost scales where applicable. Fourth, litigate well and succinctly. Arguable cases usually don't go down too well, either before an arbitrator or in court. And where terms and timelines for arbitrations have at least been set, do your best to adhere to these as best as possible, particularly in the arbitration sphere where those are by way of agreement. And fifthly, being the final takeaway, but definitely not least, the easiest way to get costs on your side is to win. Oftentimes, both in law and life, victory cures all. I now hand over to Kirsten, who will discuss cost considerations in international arbitrations and related subjects. Thank you.
Thanks, Jonathan and Nelly, for your insights. So I'm conscious of time, so I'm just going to try keep it brief before we go across to Yusha. But there's just a few additional points that I want to address to keep front of mind when dealing in costs in arbitrations. Firstly, is that arbitration is the Rolls-Royce type of dispute resolution. And I say that not just because it's the best, but also because it's really expensive. So every year, the Queen Mary University performs an international arbitration survey across all users of arbitration, from clients to counsel to arbitrators, institutes, the attorneys, everyone. And every year, without fail, costs in the arbitration remains a top concern for the users. So unlike litigation where costs are more predictable, the court is also for free as well as the judge. Arbitration involves tribunal fees, institutional fees, legal fees, expert costs, procedural expenses such as venue hire, food, travel costs. All of these can escalate very quickly, especially when you are in the international arbitration realm where we're working in euros or dollars or pounds. So effective cost management and strategic planning is essential to ensure arbitration remains an efficient dispute resolution mechanism. So while costs are a well-known concern in arbitration, just like Nelly said, it's not about the final award. They also shape how the case is run from the outset. So one of the biggest challenges for practitioners is balancing a thorough case preparation with cost efficiency. So this brings me to the key issue of what costs can actually be recovered and how tribunals assess whether these costs were justified. As mentioned above by Nelly, arbitration allows for a broader cost recovery. So unless agreed otherwise in the agreement, parties are not constrained to high court tariffs or scales. Rather, costs must be reasonable, not simply what the party chooses to spend. And how the tribunal assesses reasonableness. They look at factors such as proportionality. So is your cost justified given the dispute's complexity and the value? Necessity, were the expenses essential or could they have been avoided? And the conduct of the parties. And in reasonable procedural tactics, they could result in adverse cost orders. So don't try to go all Stalingard if you are in an arbitration. An example as well is if parties incur excessive expert fees, but that issue that the expert is opining on is no longer in dispute, well, the tribunal won't award those costs and they'll carve it out. So since cost recovery depends on reasonableness, parties can reduce uncertainty by addressing costs before a dispute arises. A well-drafted arbitration agreement or even procedural directives can set clear criteria on cost allocation, which helps to manage expectations and avoid disputes over excessive spending. For example, in an agreement, you can agree on allocation of costs. So each party bears its own costs or costs follow the event. You can agree on a scale such as attorney-owned client, or you could agree on a third-party taxation method. So instead of using a taxing master, parties can agree on an independent cost consultant whose decision will be final and binding. But as with all things dispute resolution related, even with a well-drafted cost provision, unexpected expenses can and will arise during an arbitration, which makes it crucial to manage your client expectations throughout the process. And this is the foremost job of an attorney when dealing with costs and client expectations. This is where all the disputes arise. And as a result, to avoid this, to mitigate this, attorneys should provide realistic cost estimates up front before the dispute even kicks off. And then don't just stop there. You give regular fee updates. So you get unexpected spikes in costs due to unforeseen interlocutory applications. This leads to dissatisfaction if it goes away from the initial estimate. Also advise on cost-effective strategies. We're in arbitration, so we have that flexibility. So try and streamline your proceedings to avoid these unnecessary proceedings. Well-managed cost communication, it builds trusts and it strengthens your client relationships, especially as a young practitioner, as we all are. This is how you're going to build your practice and get those repeat instructions. But like usual, managing client expectations is just one part of the equation. We also have a role to play in shaping how the arbitration is conducted. So rather than defaulting to your traditional, often costly practices, we should actively seek to innovate and modernize these solutions to streamline proceedings. So just signing off, I'm just going to give you a few key takeaways on how I think that we should be approaching costs in arbitration more effectively. Firstly, winning does not mean a full cost recovery in arbitration. Tribunals assess reasonableness, not just what was spent. Even successful parties may have costs reduced if they were excessive or unnecessary. Secondly, as young practitioners, we have an opportunity to challenge outdated practices. Instead of blindly following what are really archaic high court style procedures, we should look for innovative ways to streamline arbitration proceedings and control the costs. Some practical steps include limiting excessive discovery and focusing on key document disclosure only. Also, we have AI, so we should be implementing AI tools to increase efficiency in document review and case presentation and preparation. We should also be encouraging procedural flexibility to avoid unnecessary hearings and delays. So proactive cost management is a key skill. Understanding recoverability and structuring your arbitration efficiently will add real value for clients. Ultimately, the future of arbitration depends on modernizing the processes. We need to evolve with the times and structuring, and young practitioners, well, we are really well placed to be able to drive this change. So enough from me. Now I'm going to hand over to Yusha, who you have not met yet, but he is the driver behind today's webinar. Thank you, Yusha, and I'm sorry we stole a little bit of your time. But Joe, I think if you have any questions, by the way, just put them in the Q&A and we'll deal with them at the end. Thank you.
Perfect. Thanks so much, Kirsten. Thanks so much, Jonathan and Advocate Nelly. As Kirsten mentioned, I'm Yusha Davidson. I'm one of the founders of BriefCo, a legal cost consultancy with operations throughout South Africa. I'm just going to share my screen and somebody can scream at the top of their lungs that they can see it. Please, just a thumbs up from Kirsten or Jonathan or Advocate Nelly, please.
We can see it. Thanks, Yusha.
Perfect. Just before I came on this webinar, I got one of the funniest settlement offers in arbitration, where the other side offered to surrender all of their smart shopper points to make the taxation go away. So I'm still busy mulling over that deal as we speak. Perfect. Let's get into it. So the law of costs. Firstly, there's a distinction in the law of costs between litigious costs and non-litigious costs. But for today's purposes, we'll be focusing on your litigious costs. Now, litigious costs simply refers to where you've gone through arbitration, an arbitration award has been granted, and costs have been awarded in your favor. You're now required to prepare a bill of cost, which essentially sets out all the fees and disbursements that you can recover from the losing party. Now, traditionally, if you're looking at the Madge Court, the High Court, the SCA, or the Concourt, you will rely on prescribed court tariffs. So in arbitrations, this is where a little bit of the distinction comes into play. Traditionally, again, when you prepare a bill of costs in your Madge Court, High Court, or the like, you're presenting that bill of costs to a party known as the taxing master, who assesses the reasonableness and necessity of those fees set out in the bill of costs. Now, you'll see there's a little bit of an example of a bill of costs that's set out on the slide, and that then gets presented to the other side to assess whether or not they agree with the amounts. Now, in arbitrations, the governing rules for arbitrations is Article 13 of the Domestic Arbitration Commercial Rules and Section 35 of the Arbitration Act. Now, they've both borrowed, the Domestic Commercial Arbitration Rules has borrowed the wording straight from the Act, Section 35 of the Act, and essentially both Article 13 and Section 35 provide for a very similar cost provision. And essentially it says that if there's no agreement between the parties, the arbitrator can actually decide what cost scale is applicable, who should bear those costs, in what proportions, and what costs are all included under that. Now, this is where we start getting into the problems. The first thing is that what happens if your arbitration award comes, and this is generally, I would say in about 95% of the arbitrations that we're dealing with, this is the problems that we're getting. There's no agreement between the parties about how to regulate the cost of the arbitration, and instead the arbitrator in the award, costs are being dealt with. Now, in the award, there's no reference to which tariff is applicable. Are costs being awarded in terms of the magistrate court tariff, the High Court tariff, the SCA tariff, the Concourt tariff? Each court has a different tariff. Which one are we applying here? Secondly, which jurisdiction is applicable? The practices in Western Cape are completely different to the practices in Joburg, in Pretoria, in Mbombela, in Mafikeng. There's never any distinction between which jurisdiction is applicable. The next thing is how are we going to be treating council's fees? Council's fees, again, are not only impacted by the jurisdiction, but also certain limitations that we put on council's fees. Then, additionally, your arbitration awards often don't include how the taxation process is to be handled at all. So what this would entail, are we relying on a private taxation process? And a private taxation process entails us appointing a private independent taxing master, and that independent taxing master will then adjudicate on the bill of cost. Now, the biggest problem over here with appointing an independent taxing master is that the going rate is generally 30,000 Rand per day to appoint an independent taxing master. Now, where the arbitration award makes no reference to the appointment of an independent taxing master or the taxation process in general, who's going to be covering these costs? Is it the losing party? Is it the winning party? Is it shared by both? In the absence of anything said by the arbitrator, the reality is that both parties then share the independent taxing master's fees equally. Alternatively, you can then go back to the High Court. We can have that arbitration award made an order of court, and we can simply rely on the free government services by utilizing the taxing master of the High Court. Again, the problem here is that we're then faced with the delays. The next available date in Western Cape, Johannesburg, and Pretoria is 2026. Now, the default position. Because of the value of these claims that's generally going through arbitrations, it's assumed by all the parties that where it's silent on the applicable tariff scale, we are looking at the High Court tariffs. The High Court tariffs are set out in Rule 70 of the Uniform Rules of Court. Now let's just have a look at what these rules entail. Now this is where the devastation starts. Firstly, Rule 70 makes a distinction between time-based attendances, your drafting, perusal of documents, and then your miscellaneous attendances. Now, your time-based attendances include your consultations, your hearings at court, conferences, sorting and paginating documents, right? Now, the tariffs, when looking at time-based attendances, they make the distinction between an attorney and a candidate attorney. Now, everybody here knows what the distinction between an attorney and a candidate attorney is. The problem with the tariff is that it does not define what constitutes an attorney. What do I mean by that? So, an attorney can be somebody that's newly admitted or somebody that has been practicing for 50 years, who has 50 years of experience. Now, we know in practice, a newly admitted attorney's hourly rate is completely different to an attorney who has been practicing for 50 years. But the tariffs treat them exactly the same. Now, currently, the maximum hourly rate for an attorney is 1,668 Rand. The maximum hourly rate for a candidate attorney is 520 Rand. Now, in the tariffs, it then takes it a step further. They make a distinction between the drafting of important documents and the drafting of simple documents. Now, important documents would be something like your statement of claim or your statement of defense. A simple document would be something like maybe a confirmatory affidavit or even a filing sheet or filing notice or the like. Now, for drafting of important documents, the tariff allows you to recover 417 Rand per page, whereas the drafting of simple documents is recovered at 168 Rand per page. I don't think you can be clever and make your font size 300, and then you can suddenly recover significantly more fees on taxation. The reality is that there is a calculation, a formula for what constitutes a page. Now, for every 250 words, that constitutes one page. The perusal of documents is also allowed at 84 Rand per page, again per page, meaning the applicable formula. Now, just before we move on, you can already see that the tariffs are not in line with the realities of practice. And that's why if in your arbitrations you move forward with a default position, the maximum that your experienced attorney who's running this arbitration is going to get per hour is 1,668 Rand. From the data that we're processing, that's generally what a second-year candidate attorney is charging in Gauteng. Now, the Uniform Rules of Court creates certain rules that are applicable to your advocates as well. Now, there are two forms of taxation that currently exist in South Africa. One for attendances prior to 12 April 2024 and one from 12 April 2024 onwards. So, how are council's fees treated prior to 12 April 2024? So Rule 69 of the Uniform Rules of Court is a very, very strict provision. You know, I often get clients coming to me very excited that they got the cost of two counsel, they got a cost order, and part of that cost order is the cost, including the cost of two counsel, and everybody's celebrating. We quickly have to burst that bubble and remind them that Rule 69 of the Uniform Rules of Court creates a cap on the costs of your second counsel. Now, what does this cap entail? On a party-and-party scale, your second counsel's fees or your junior counsel's fees are immediately capped at 50% of what was allowed for your senior counsel. Now, as an example, let's just say your senior counsel invoiced you 1 million Rand for the arbitration. We go to taxation, your senior counsel's fees are actually allowed by the taxing master at 800,000 Rand. The most that your junior counsel can then recover is 50% of that 800,000 Rand, being 400,000 Rand. Doesn't matter how much your junior counsel charged, that fees is capped. On an attorney and client scale, that cap increases from 50% to 75%. Again, this is all contributes to why your clients would recover significantly less fees than what they were actually invoiced for. Now, how has counsel's fees changed as of 12 April 2024? So as of 12 April 2024, they've gotten rid of the cap rule. So no longer is your second counsel's fees capped at 50% on a party-and-party scale or 75% on an attorney and client scale. Instead, they've come up with scales, scale A, scale B, scale C. These scales reflect the maximum hourly rate that your advocate can recover on taxation. It's all in increments of 1,500 Rand. So scale A being the lowest at 1,500 Rand and scale C being the maximum at 4,500 Rand. Now, I often see matters where somebody is just saying, okay, of course we want the maximum scale. Of course we want to recover as much as possible for our counsel. Let's always ask, in our relief, let's always request scale C for our counsel, but it doesn't work like that. The reality is that in your arbitration awards, it has to be specifically clear what scales are applicable to absolutely every single counsel. Now, again, scale C is not automatically applicable. There are three factors that determine which scale would be appropriate to award for each counsel. So those three factors are: one, the complexity of the matter. Now, the complexity of the matter is not only the complexity of the legal issues to that matter, but also the complexity of the facts of the matter. So you could have an extremely complex factual matrix that actually with a very simple legal issue, but it can still justify an award of scale C. So of course, the greater the complexity, the more likely you are to be awarded scale C. Now, the value of the claim, simple math. The greater the value of the claim, the more likely you are to be awarded scale C. The importance of the relief. This does not only go to the importance of the relief for the parties to the matter, but also the importance of the relief to broader society. So maybe it's impacting a community, it's impacting an entire industry, and in that respect, the greater the importance, the more likely you are to be awarded scale C. Now, there's this punishment. I call it a punishment because it feels like that on taxation. There is a punishment if your arbitration award does not make reference to the applicable scale for counsel. Automatically, your counsel gets awarded scale A. So you could have used 3 senior counsel. and that senior could have asked for scale C for all 3 senior counsel, and instead the arbitration award is silent. Every single one of that senior counsel is being awarded an hourly rate of 1,500 Rand. Now that will devastate your client on taxation. So what I would suggest, always in your relief, and once you get that arbitration award, always make sure that there's a reference to the applicable scale for counsel where it's applicable. Now, how do they actually assess an advocate's invoice on taxation? Now, this is the most interesting thing. These are unwritten rules, unwritten practices that only exist if you are familiar with taxations. Okay, so you present an advocate's invoice, you just attach it as an annexure to a bill of costs, and you're now presenting it to the taxing master, be it at court or through an independent taxing master. Now, where the jurisdiction is the Western Cape or Pretoria, this is how we assess an advocate's fees. An advocate peruses important documents at a rate of 40 pages an hour and peruses unimportant documents at a rate of 60 pages an hour. So let's, for example, say that a statement of claim is 120 pages. We know that counsel peruses at a rate of 40 pages an hour. So 120 divided by 40 means that in the Western Cape and Pretoria, the maximum that my counsel can recover is 3 hours for perusing that statement of claim. It does not matter if that counsel charged the day fee. Immediately, we're reducing that day fee of 10 hours to 3 hours. So we're taxing off 7 hours. Counsel drafts at a rate of 4 pages an hour, and counsel settles at a rate of 6 pages per hour. Now, settling just refers to where the practice where an attorney drafts the initial papers and it then gets settled by the advocate. Now, let's take the same example. If the advocate drafted a statement of claim of 40 pages, we know that the maximum that that advocate can recover on taxation is 40 pages divided by the rate of 4 pages an hour, so 10 hours, so a day fee for that. Again, it does not matter what is reflected in that invoice. We strictly apply these unwritten practices on taxation. Now, Johannesburg, if the jurisdiction, we determine the jurisdiction for the arbitration to be Johannesburg, and that can either be by agreement or based on the domicile and the seat, the domicile of the parties or the seat of the arbitration. If it's Johannesburg, there is a separate formula that we're going to apply. Now, Johannesburg has one of the strictest taxation practices for the assessment of counsel's fees, and it's the only court, the only jurisdiction that applies the following practice. So, your senior counsel settles and drafts at an all-inclusive rate of 1,700 per page, and junior counsel doing the same, but at half the rate, at 850 Rand per page. Now, there's some interesting wording over there. The all-inclusive rate. What does this actually mean? So let's take an example. A statement of defense. A statement of defense that's 10 pages. If senior counsel drafts that statement of defense of 10 pages, we know that the maximum that senior counsel can get is 1,700 Rand times by 10, so 17,000 Rand. However, what does that caveat all-inclusive mean? All-inclusive in Johannesburg means it's every single attendance that was necessary to put that counsel into a position to draft that statement of defense. So what would some of those attendances be? The initial perusal of the brief, the first consultation to take instructions, the perusal of the statement of claim, the annexures to the statement of claim, the next consultation to draft the statement of defense, the perusal of the annexures to the statement of defense. So suddenly you can see that 17,000 Rand for drafting a 10-page statement of defense is nothing at all. Your advocate is recovering nothing at all. And that's why Johannesburg is considered the strictest market, the strictest jurisdiction to have your taxation regulated under. Now, from the data that we're processing, when relying on this default position of the uniform rules of court, so where the parties haven't agreed, the arbitrator hasn't said anything, and we are now relying on the uniform rules of court, the reality is that on a party and party scale, your client is looking at recovering 15 to 30% of the total amount that was invoiced. In other words, if you invoice your client 100,000 Rand, your client is looking at only recovering about 15,000 Rand worth of fees. On an attorney and client scale, that percentage increases from 15 to 30% to 30 to 45%. So how can I recover more for my client? Well, firstly, you have to have clarity. Clarity on 4 things. The tariff, what tariff is going to be applicable? How am I going to deal with council's fees and taxation? Which jurisdiction is applicable? And what process are we going to follow? Now, all of these things have to be set out in detail, either in your arbitration agreement, in your pre-arbitration minute that's dealing with the process of the arbitration, or in your arbitration award. So, some of my suggestions. The first one, your tariff. If we're going to rely on the High Court tariffs, the Uniform Rules of Court, why not change that tariff to be more in line with the realities of practice? So saying, we're going to increase that tariff amount. Yes, we'll apply Rule 70 of the Uniform Rules of Court, but we're going to double or triple our tariff rate so that it's more in line with the realities of practice. Alternatively, you can simply say in your pre-arbitration minute or in your arbitration agreement that we're simply going to allow the reasonable fees, and that can be calculated as a capped at the percentage of what the total value of the claim is. Now, if you rely on the Uniform Rules of Court and we're simply saying that it's 2 times or 3 times the tariff amount, this will inevitably result in a significantly higher fee recovery for your client. Now, council's fees. On taxation, council's fees takes the biggest knock, and that's because of those practices that have developed in each of those jurisdictions. So what I would suggest in your pre-arb minute or your arbitration agreement is to say that council's fees will be recovered based on the actual fees that has been charged by council. So whatever council has charged you, that is what you're going to be recovered. That's what you're going to recover for. The jurisdiction that's applicable, if there's no agreement on to say that that all of council's actual fees can be recovered, or that we're going to double or triple the tariff, I would always provide for Pretoria High Court taxation practices to be applicable, because as you've just seen, Johannesburg will devastate you and your client on taxation, whereas in Pretoria, you're often coming out with significantly more fees than you would in the Western Cape and in Johannesburg, and that's based on the data that we're processing. Now, the most important one is the process. Again, in your pre-arb minute or in your arbitration agreement, you want to regulate the taxation process. We're often seeing that everything in an arbitration is regulated except the taxation process. Now here, there's two processes that you can rely on. One, where the taxing master of the High Court taxes the bill of cost, or the second one, where the independent taxing master deals with it. Now, pros and cons. The pro with going to the High Court to have the matter taxed is that it's completely free. The cons of going to the High Court is the significant delays that it takes. And the reality is that you also would have to make that arbitration award an order of court, because you'd first have to get a case number in order to be able to apply for the taxation date. Now, if instead you choose the independent taxing master route, there's pros and cons again. The pros, it is very, very quick. We can set a date within a week, 2 weeks, and the entire taxation process can be handled within a month. The cons, it is very, very expensive. Arbitration matters, the bills of costs are often quite lengthy, and what you find is that the independent taxing master will spend a day prepping and maybe a day or 2 hearing the matter. With 30,000 Rand being charged on average per day, you're looking at an average cost to run an arbitration taxation of about 90,000 Rand, excluding VAT. So it's a very expensive process to utilize an independent taxing master. And that's why I would always add the main caveat to the appointment of an independent taxing master. And that is, who is the party that's going to be liable for that independent taxing master's fees. Now, this is generally never included in the award, the agreement, or the pre-op minute. I would always say that the independent taxing master's fees should be payable by the losing party. So the costs of the taxing master are simply just costs in the cause. Now, I hope that some of these suggestions will significantly increase your client's recovery on taxation, but the reality is that a lot of the work gets done pre the cost consultants getting involved. You have to think about costs from the very outset of your matter. From when you're concluding your arbitration agreement, you need to regulate your costs. The tariff, the council, the jurisdiction, and the process. If you forgot to do it over there, do it in your pre-op minute. It has to be dealt with. Half the battle of your taxation is won when we have a clear outline of these 4 principles. Thank you so much. I'm happy to take some questions. And yeah, I see there's a good couple in the...
I see there's some questions in your Q&A box, but I think they're best for you to answer.
Sure. So are there any proposed changes to the prescribed tariffs to align them with the realities of practice? Vian, this has been something that's been coming on. They've been threatening an increase in the tariffs. You know, every year. Recently, the perusal rate increased from 78 Rand all the way to 84 and 82 and 84 and the cost consultant community celebrated for that 6 Rand increase. Now, we are engaging with the Legal Practice Council in order to change these tariffs, but honestly, it has been very, very slow. So I wouldn't expect any change anytime soon. This addition to the regulation of council's fees has been one of the most welcome changes. The reason being is that there was often a debate on taxation that would take up most of the time on what hourly rate would be applicable for your advocate. So they are coming along with certain changes, but in terms of aligning it with the reality of practice, I don't see that happening anytime soon. We have another question. With the scales, with the applicable scales, scale A, B, and C, are they based on one's experience? Are these costs determined just like that throughout the country? Are these costs... Okay, so the scales are determined across the country. The jurisdiction doesn't matter. They apply very strictly those applicable scales. Yes, the one's experience is applicable. So as an example, if you were junior counsel charging 800 Rand per hour or 950 Rand an hour, there's no basis for you to request scale C of 4,500 Rand. It doesn't, just because you've asked for scale C and been awarded scale C, does not mean we can recover scale C. You still have to actually look at how much your actual counsel was charging, and if it's less than the applicable scale, it would be capped at that amount. So experience is applicable, but it's not a justification for awarding a specific scale. So counsel's fees, does a page still mean 250 words, both for reading and drafting? This, Rob Foden, this is the biggest debate that's still going on. In Western Cape, we're having this argument every single day with people. So Rob's question, if you're perusing at 40 pages an hour, if you're drafting at 4 pages an hour and settling at 6 pages an hour, does that mean 250 words? Yes, it does mean that as well. The problem then is that you'd often find that counsel's heads of argument, a lot of the formatting is different, a lot of the amount of words on the page is completely different. So we've constantly argued for the formula count of 250 words to also be applicable when assessing counsel's fees. That, again, it's not a hard and fast rule, so it is applied differently by each taxing master. Ayusha, please provide guidance on specific wording the taxing master scrutinizes before being satisfied with what counsel bills for. Okay, so counsel's invoices, to this day, there's still a significant practice by counsel to engage in the practice of block billing. Now, block billing is where you put a number of attendances, let's just say perusing brief, attending consultation, drafting statement of claim, perusing statement of defense, 4 days. There is absolutely no way for anybody to determine how much time the advocate spent on each attendance. So it's very important for your advocate, firstly, to understand how the taxing master assesses an advocate's fees in that relevant jurisdiction, and they prepare their invoices in line with that. So as an example, drafting statement of claim, we know it was 30 pages. This is the rate that can be recovered. So yeah, good afternoon. Thank you for the presentation. Is there any way you can provide some insight on the Mpumalanga High Court's unwritten taxation principles? So, Robin Zealy, the only court that has a different taxation practice in the entire country is Johannesburg. Everybody else follows Pretoria and Western Cape. They all rely on the same rule. So, if you're in Johannesburg and you're litigating out of there, or your arbitration falls within the jurisdiction of Johannesburg, either based on agreement or on the domicile of the parties, your counsel's fees are going to be rough. But it's going to be exactly the same everywhere else. What is the position in respect of matters that were issued in the High Court and the parties subsequently agreed an arbitration, all this being prior to April 2024, and not having insight on the importance of confirming the cost recovery process? In that instance, are parties constrained to follow the position prior to the High Court amendments, or seeing that they are now in an arbitration, are they at liberty to amend, alter the position to deal with these potential taxation issues? Yes, okay. So a lot of matters, and this doesn't only relate to arbitration. So basically, the question is they've issued papers out in the High Court. This was all done prior to 12 April 2024, where the old taxation principle was applicable. The question then becomes is that what happens if the matter moves to arbitration, or even, let's just say, it stays in the High Court and they haven't asked for the applicable scale to be considered? Now, there is a rule in the Uniform Rules of Court that allows you to go back to the arbitration. Let's say a award does come out. You can go back to I think it's Rule 41. I must just confirm that. Rule 41 of the Uniform Rules of Court, which allows you to go back to say that there's clearly been an omission in that order, in that arbitration award, because it does not provide for the applicable scales. So recently, in one of the matters that I dealt with for arbitration, we got instructed to prepare a bill of cost. The arbitration award made no reference to the applicable scale for counsel. Exactly the reason being it was dealt with prior to 12 April 2024. We simply then wrote to the arbitrator to say, please, can you consider which applicable scale would be applicable, considering that there's been a change to the law. So you can just make the request at any stage and just file supplementary submissions to justify the applicable scale. Vincent Manco, what has been your experience in dealing with witness fees in domestic arbitrations, considering that the subpoenas are still issued in the magistrate's court? Okay, so witness fees. Witness fees are, there's firstly the distinction between your witness. Sorry, Jonathan, are you? Okay, I can deal with the question. So
Yeah.
witness fees. Distinction between your ordinary witnesses versus your expert witnesses. Expert witnesses, generally, you want your arbitration award to provide for those costs. The only way there's an opportunity to scrutinize those costs for expert witnesses is for the cost consultant to bring market competitive competing rates to justify a lower rate to the current expert witness, right? For an ordinary witness, there are tariffs that are applicable to ordinary witnesses, and unfortunately, as Vincent said, those are very strict. There's a tariff applicable to that, and it is very, very low. I think it's in a couple of $100 per day, with a little bit of traveling time and subsistence for food. But other than that, if we had to call, let's just say, an auditor who's appearing as a witness but not an advocate, not as an expert, it wouldn't then allow them to recover their general hourly rate. There's a tariff that's applicable to ordinary witnesses, unfortunately. But again, Vincent, if you know in your pre-arb minute at that time you're calling witnesses, or in your arbitration agreement, regulate the costs of that witnesses as well. Because the beauty of arbitration is that everything is done by agreement.
So you should maybe, Vincent, if I could just jump into that. We recently had that experience where we had a factual witness who was no longer employed by our client, and he wanted to be reimbursed, and the tariffs, and this was in an arbitration, the tariffs were not good enough for him. It's not good enough for anyone. So you know, he really did go over and above. He had a lot of he lost compensation, but it wasn't, you know, like compensation that we could claim. You know, it was after hours compensation kind of stuff. So what we did, we actually decided to play open cards, and we first wrote to our opponent explaining the situation, asking if they would agree to us remunerating him at a certain rate. And then we also then took that then to the tribunal, because we were worried about having an argument raised later down the line that we had that his witness testimony was compromised and it was no longer independent. So every situation is a factual situation, but there we decided to play open cards, and everyone ultimately agreed to be able to reimburse him. But sometimes it's best to just ask.
Great. Thanks so much, Yusha and Kirsten. I think we've come to the end of our time together today, but thank you everyone for joining us, and I hope you found this to be an informative and helpful session. We appreciate you joining, and Yusha, a big thank you to you for sharing all your expertise and valuable knowledge. And from the Young AFSA and the BriefCo team, I think we just want to give everyone a joint thank you and wish you a pleasant evening.
Thank you.
Awesome.
And if you're not joined Young AFSA, sign up, guys. We've got some more events coming up, some more training sessions. So yeah, keep an eye on Young AFSA.
Awesome. Thank you so much, everybody.
Thank you.
Cheers,
Bye-bye.
everyone.
Bye.
Bye.
Bye. Bye.